This may well be the most consequential case in the history of humanity. Let us not allow future generations to look back and wonder why the cause of their doom was condoned. This
You just heard the climate change minister of Vanuatu describing what we're about to witness in The Hague as the International Court of Justice delivers its advisory opinion on the climate crisis. Hello and welcome. I am Lian Buan, Rappler's Justice Reporter.
And I am Iya Gozum, Rappler's Environment Reporter, and we are joining you tonight for a watch party on this defining moment for our planet. Parang ang laki na mangyayari tonight, Lian.
Actually, big deal talaga siya. So gusto rin nating mag-reflect yung coverage natin na big deal din siya. So it's now 8:33 p.m. in Manila. That's 2:33 p.m. in The Hague, Dutch time. And in 27 minutes, wow, kaya kong mag-math on air. In 27 minutes, the ICJ, or the World Court, yung Korte ng United Nations, will deliver its opinion 2 years and 2 months since Vanuatu successfully got this case to the court. So maya-maya lang, malalaman natin kung akma bang tawagin tong party o magluluksa yung mga nag-participate dito sa case na to. So a little background, basically, noong March 2023, Vanuatu, which is a country in the southwestern Pacific Ocean, katabi ng Australia, successfully got a resolution from the UN General Assembly to go to the ICJ and seek an advisory opinion. Once and for all, gusto nila ng opinion ng korte kung ano nga ba yung obligasyon ng mga bansa para protektahan ng planeta natin at ano ang pwedeng gawin kung hindi sila tutupad. This is considered the biggest case in the history of the ICJ by sheer number of participating countries because basically lahat ng UN member states pwedeng mag-submit at dumalo sa oral hearing noong December. So if ordinarily, kung sa ICJ one state versus one state lang yung naghaharap, ito parang buong mundo yung pumunta sa korte.
Right, Lian, if I remember correctly, 2 weeks yung hearings actually nung December sa ICJ. It's covered all around the world, diba? And over, I think, 100 countries participated. So, ang dami talaga.
Kaya big deal talaga siya.
Right. It's a global effort na in-start ng Vanuatu. And to set the mood, ganito ka-big deal ang mangyayari in 26 minutes. To quote the Center for International Environmental Law, this is potentially one of the most consequential legal rulings of our times. And to quote the government of Vanuatu, which initiated this case, the advisory opinion is not just a legal milestone. So this is not just for people who enjoy talking about
hindi lang to for the legal nerds, yes.
Right. It is a defining moment in the global climate justice movement and a beacon of hope for present and future generations. At this point, let's hear from Nicole Ponce, advocacy lead from World's Youth for Climate Justice, who is actually currently in The Hague. Hi, Nicole. Can you hear us? Hi. Hello.
Hi. Hello.
Hi, Nicole. Thank you for joining us. You were one of the key people working behind the scenes to make this happen, this historic moment. What's the mood among climate justice advocates right now in The Hague?
Oh, the energy is just high over here. There's a mobilization happening right now, and we are just all excited and, more importantly, hopeful talaga that it's going to be a good decision.
Right.
It's
Nicole,
been 6 years. I'm sorry.
Go ahead. It's been 6 years and...
Yeah, it's been 6 years. I'm a lawyer now, but I started this when we started with this with friends when I was still in law school. That was way back in 2019. So it's been 6 years. It's been a long-awaited moment. And I think everyone just feels the same. You think about it, you plan about it, but you don't really imagine reaching to this point just because of how difficult it was to get to this point. I don't want to, you guys probably talked about that already, but even just getting countries to vote on the resolution before the United Nations General Assembly, even before getting to the ICJ, that in itself was a feat of its own.
Right, that's amazing. How was it working alongside climate justice trailblazers for this landmark opinion?
Yeah, honestly, I'm just inspired and honored to be with such brilliant individuals. You know, we mentioned Vanuatu earlier. What's so special about this is that they even call it the Youth Advisory Opinion. Even during the United Nations General Assembly, I also had the great privilege of being there when the resolution was adopted by consensus. There was not even a vote because 132 countries co-sponsored the resolution. So it did not even have they did not even have oppositions because it did not reach to that point. So it just means that there is universal recognition of the urgency of the need to address climate crisis among countries. So yeah,
Yeah.
inspired to be around brilliant individuals.
Right, and that's what makes actually this case very special. It started by the youth, right? And it blew up into this global effort. Just last question before we let you go back to the protest and before this starts. What's the conflicts between what are the conflicts between developed and developing nations so that you're hoping will be addressed by this opinion?
Well, the first one is we are hoping that the court would recognize that human rights and climate justice go hand in hand. And more importantly, as well, to talk about the actual remedies. So we are hoping that the court will clarify that indeed major polluters have the heightened responsibility to cut emissions and protect especially those who are highly at risk to the effects of climate crisis. So we hope that the court will clarify that today and not only talk about the obligations, but equally the legal consequences and talk about reparations, be restitution, compensation. So that's what we're hoping today.
Right, and that's Nicole dialing in from The Hague. Thank you, Nicole.
Thank you very much, everyone. Thank you.
Thank you, Nicole. Oy, Iya, hindi ako OA pero kinalabutan ako habang nagsasalita si Nicole. I mean, you're so inspiring. Thank you for your work. At again, hindi sa OA pero kinikilabutan ako kasi parang we're really just about to see something happen, something historic happen. And it's really inspiring to see climate advocates, Filipino climate advocates at that, present in The Hague who carry so much hope na papaboran yung mga maliliit na bansa tulad ng Vanuatu at tulad natin, tayo, ng Pilipinas,
right,
na lagi namang biktima ng masamang epekto ng climate change. We're currently experiencing heavy rains dahil sa habagat. So relate for sure yung mga Pilipino dyan ngayon. And climate justice advocates have called this a quintessential case of David versus Goliath.
Can you imagine?
Diba? The little guys.
imagery.
Oo, correct.
Right.
The little guys versus the big guys. So yung mga literature nerd dyan, ito na yun.
Right.
Yung gusto nyong ganun, yung narrative, ito na yun. And if this advisory opinion goes the way of the big guys, iko-quote ko na lang yung Vanuatu minister para hindi
Go
sa
ahead,
akin
go
manggaling. Kapag nanalo yung mga big guys sa kasong to, the future generation will look back and wonder why the course of their doom was condoned. Siguro in Tagalog, bakit tayo pinabayaang malugmok? Parang ganon. So, really, it's a big deal. So, I will let you listen to an emotional appeal by our very own, the Philippines, Ambassador J. Eduardo Malaya when the ICJ conducted oral hearings in December. So here's a soundbite from Ambassador Malaya.
We look to it to provide authoritative guidance to address the worsening global catastrophe and to fulfill our respective obligations in ensuring the well-being of present and future generations in this shared home we call Earth. We look to...
Again, big words. We cannot highlight enough na big deal siya.
Right. For those watching or just tuning in, you can comment some of your questions and we'll try to read and answer them on air. You can also go to communities.rappler.com or download it from the Apple App Store or Play Store. And check out the app's Environment and Science channel and pwede rin kayo mag-send doon ng opinions and questions kung meron kayo para sa amin. Sorry, I just had to plug it in.
But we will have two lawyer guests who practice international law and climate law to help us understand this. And inevitably, they will hear a lot of big words tonight.
Right.
At let's explain muna siguro the science of it, Iya. Ipapasa ko na sa'yo to. Siguro maririnig nila mamaya ano ba yung ibig sabihin ng anthropogenic greenhouse gas emission. Ano bang nagdulot nito? Sino bang may kasalanan? Take it away.
The big questions. Pero yung keyword talaga dito, Lian, is anthropogenic. So just to emphasize na this crisis is human-made. Diba? Kasi you ask, ano ba yung mga greenhouse gases na to? So, okay.
Kaya mo yan. Meron tayong chips dito, kaya mo.
There are some of the gases that contribute to climate change. These are emitted because of human activities. So, for example, you'll hear this a lot na. Carbon dioxide, emitted yan because of we burn fossil fuels. And we burn fossil fuels because we need electricity, diba? Ginagamit siya for transport. There's methane, which is emitted from landfills, so our waste natin yan. From rice farming even, so we get emissions from producing the food that we eat. And another is nitrous oxide, which is also emitted from burning of fossil fuels and agricultural practices. So they're called greenhouse gases kasi they create this greenhouse effect. So natatrap yung heat sa atmosphere natin, which then causes global warming. And with enough time, when enough time passes, tapos nagtuloy-tuloy yung ganitong warming, nagkakaroon na tayo ng, eto na, climate change. And this is why it's important to note that this is anthropogenic, human-made ang climate crisis. This is because since the Industrial Revolution, so nung nagde-develop na tayo, well, hindi pala tayo. Sorry. Sila, yung mga ilang piling bansa, sila talaga yung nag-accelerate ng mga emissions na to which warmed the planet. So, the biggest emitters like, for example, the US, no? We have to keep that in mind na, and this leads us to the questions that we're asking in The Hague. Ano ba yung legal obligations ng mga bansa na to na nag-emit hanggang sa napunta na tayo sa sitwasyon na merong climate crisis, 'di ba?
Wow, best in science ka doon. Sobrang best in science. For sure, proud yung science teacher mo from high school to college. You want to introduce a soundbite from the climate change minister of Vanuatu.
Right. So saying all that, let's hear Vanuatu's climate change minister, Ralph Regan-Vanu.
A handful of readily identifiable states have produced the vast majority of historic and current greenhouse gas emissions. Yet other countries, including my own, are suffering the brunt of the consequences. The question is therefore simple at its core. Having regard to their obligations under international law, have those states responsible for climate change acted lawfully?
Lian, you have to help me here because you put me on the spot for the science. For sure, maririnig din natin mamaya customary law, international human rights law, treatises. Ano ba to? Please explain to us.
Well, unlike you, meron akong call a friend na ready na sa Zoom. So why not let's ask someone who practices international law. Dahil kasi AO to hindi to decision, hindi to ruling, it's an advisory opinion. Kaya yung hashtag makikita nyo, AO, let's go, or ICJ-AO. So let's ask an international law practitioner, and to tell us more about what an AO is, we have dialing in from Australia, Ross Togade, who's currently a doctoral researcher on international law. I know Ross from UP Institute of International Legal Studies kasi favorite ko yung takbuhan kapag may tanong ako on anything PIL or public international law. So, Ross, hello, hindi na natin natuloy yung dapat ganito natin bago ka umalis, pero ito. So, pakisagot yung tanong niya. Simulan ko muna sa, ano ba yung AO kasi, Ross? What is it?
What is an advisory opinion?
Just jumping off from what you just said, Lian, no, yung binabalak dapat natin na conversation is with another court also in The Hague. So this AO, and I'll get to that in a while, the AO will be issued by the International Court of Justice, the ICJ, not to be confused with the ICC. They're in the same city. But
Kaya mong i-bike? Kaya mo bang i-bike yun, Ross?
Magkaiba po sila, and this is always the bar question asked of law students in the Philippines. What's the difference? So the usual answer is, well, in the ICJ, you have states doing the litigation, Whereas in the ICC, it's an individual person who's being made liable for an international crime. But that aside, no, an AO is one of is a particular kind of issuance that may be made by the ICJ. So I just mentioned a while ago that usually it's the states who do the litigation before the ICJ. So yung mga pinakasikat na mga kaso sa ICJ, Nicaragua versus US, Russia, Ukraine, of course, and more recently South Africa, Israel. So if you look at the case names, so they usually have a case name and then the name of the parties. So if you notice, it's state A versus state B, or usually there are multiple states involved. But in the case of an advisory opinion, it is not what we call a contentious case. Okay? Iba siya. Okay? Essentially, an advisory opinion, it's it's legal advice or legal opinion that is provided by the ICJ, okay, on certain or specific legal questions. Now, the legal questions, according to the ICJ statute, read in conjunction with the UN Charter, no, yung advisory opinion, ang nagtatanong ay organ of the UN. It's usually the General Assembly, the Security Council, or any other UN organ as may be authorized. So they must have specific authority to request for an advisory opinion.
Kaya
in this
crucial
case,
na
the
nakuha
GA.
ng Vanuatu yung
Yes.
UNGA. Okay.
Yes, in this case, it was the GA through the resolution that asked the two main questions that is now the subject of the advisory opinion. So, an advisory opinion, unlike a contentious case, which will decide, for instance, on the interpretation of a treaty, or is there any state responsibility that emerges from an international, the breach of an international obligation. Iba ang advisory opinion because it clarifies, okay, legal obligations, and it's not primarily intended to settle disputes between states. So kung mapapansin nyo dito, walang particular state that is named in the request. It's the GA that has issued the request for the ICJ to provide an advisory opinion. So they are not legally binding in a way that contentious cases are legally binding, but they are very, very special, no? Especially in our current context. And I'll get to that because the ICJ AO is actually not the first AO on climate change that has been requested by states. So just this month in the Inter-American Court on Human Rights, they also issued an AO on climate change, and last year, the ITLOS, or the International Tribunal on the Law of the Sea, also issued an advisory opinion pertaining to climate change, but of course concerning the maritime environment. So increasingly, we see this trend, this strategy among states, especially smaller states. So in fact, the ITLOS advisory opinion was requested by the group of small island states, okay, to, in a sense, leverage their solidarity and take advantage of that available mechanism in international law. Kung hindi man sila makapag-bring ng actual suit before the tribunals against another state, at least they can request for an advisory opinion through the authorized bodies to clarify what is the current state of international law, what could be the legal consequences, for instance, of certain acts from the purview or from the framework of current international law.
Ano lang natin i-simplify ko lang ng konti. Sinabi mo kanina, it's not legally binding like the other forms of what will come out of the ICJ, pero special siya. So how special will it be? Kunwari, we get the most favorable opinion ever. Ano yung effect niya? Ano yung special effect nun?
Okay. I'll answer the question by way of an example of another advisory opinion. So, a few years back, the Chagos Islands has been the subject of an advisory opinion. Okay? Essentially, ang tinanong doon sa advisory opinion proceedings in the Chagos Islands, nakumpleto ba yung decolonization process sa Chagos Islands under then the authority of the British. Okay?
Oh, favorite
So
ko yan.
napakamasalimuot dahil ilang dekada, 'di ba? Ilang dekada yung tanong kung meron bang authority still ang British government over the Chagos Islands. And it was not a contentious case. It was actually an advisory opinion, and the legal framework that they used was the decolonization framework of the United Nations. So very important yung Chagos advisory opinion because the impact of that particular advisory opinion was to tell everyone, the entire world, that the process of decolonization was not actually completed. There are continuing violations of that decolonization framework under the UN Charter. And if you listen to the later commentaries of the lawyers involved in that case, most notably si Philippe Sands, he actually pointed out one interesting, let's say, concrete consequence after the advisory opinion, the stamps that they were using with respect to Chagos Islands, natanggal lang any references to the British. So that's one very small example, but very impactful because it shows you a shift in the interpretation of international law, or the interpretation of certain legal obligations under international law. So although it does not have that coercive power to immediately tell states na, well, this is what you should do under the pain of penalty, it does not have that effect. But what it does have is that persuasive, I would even say morally and politically persuasive weight to tell states, hey, this is a problem that we have to collectively face, and it is the entire world that is affected by consequences of climate change.
I can have this conversation forever, but we have very limited time and we have one more lawyer after you. So, Ross, I'm gonna have to let you go muna. I'll catch up with you later. Thank you so much, Ross Togade. Dialing in from Australia. Sabi nga ni Ross, di ba, parang sometimes merong maliit na effect, pero malaki naman talaga yun. So, we can only hope na matutupad yung sasabihin sa advisory opinion. And the reason why we say hope, kasi marami na ring frustration sa maraming panahon. Frustration mainly kung naging effective ba yung mga climate treaties. So, ano ba yung mga climate treaties? Dito na ako magbe-best in kung ano man to.
Recitation.
Best in recitation. So, yung mga climate treaties, pag narinig nyo siya, ito usually yung UN Framework Convention on Climate Change or UNFCCC ratified in 1992. And the Paris Agreement, I'm sure familiar sa marami. From the UNFCCC, maraming agreements ang nabuo. But the Paris Agreement adopted in 2015 is the most ambitious climate agreement. Kulang na lang magparaiso yung mga
historic
world leaders doon.
In 2015.
Yes. The thing with this agreement is pinagkasunduan kasi to ng mga bansa, and to be pessimistic about it, kung umuo ang mga bansa dito, alam mo na nakuha nila yung gusto nila, na protektahan nila yung gusto nilang protektahan. Kaya yung criticism sa Paris Agreement at sa climate treaties, parang wala naman masyadong nagawa para sa planeta natin. Kaya nga tayo, that's why we have reached this point. At kasi kung di naman natin masusunod yung pinagkasunduan, parang bakit pa tayo nag-climate treaty? Correct. Naglolokohan naman tayo in the first place. So, outside of the climate treaties, merong mga ibang human rights framework, international law frameworks. So, malalaman nyo, maririnig nyo in the duration of this coverage na babanggitan ng kung sino-sino na let's invoke other laws aside from the climate treaties. Let's invoke the international human rights law.
Parang incorporating other frameworks.
Correct.
Kasi nga, the current framework is not
does not work,
enough.
Sabi nila, does not work. So, ang downside din naman ng mga international law frameworks na to, some will say is, treaty din naman to na pinagkasunduan din naman ng mga iba-ibang bansa. So, baka the same countries is parang nabakuran na din yung mga interest nila. So yun yung mga climate treaties and other international law frameworks. So pag narinig niyo yung mga big words na yun mamaya, that's what they mean. To further clarify this point, we'll play a soundbite from the former Solicitor General of the Philippine Solicitor General Menardo Guevara during the ICJ oral hearing as well noong December. Walang audio.
We're not hearing anything. But
In no uncertain, when we are not being drenched, we are being scorched. Now, more than ever, the authoritative guidance of this court is being sought to express in no uncertain terms that the contributory conduct of states in relation to climate change is bound by established conventions, customary law, and general principles. When we are not being...
God, I love that line. That line became my headline.
Favorite mo yan, when we are not being drained, we are being...
When we are not being drenched, we are being scorched.
So for the information of everyone, yung nag-submit, yung Philippine team na nagbigay ng submission sa ICJ is mainly the Office of the Solicitor General, assisted of course by the Philippine Embassy in the Netherlands, at tinulungan sila ng mga taga-UP. And we have on the line someone from that team, from one UPIILS to another. We have on the line Niner Giao, the Head Legal Officer and of UPIILS and Operations Director of Para Bukas. Hello Niner, salamat sa pagbigay mo ng oras sa amin ngayong gabi.
To be here.
Yes, okay. Nagkaroon lang ng konting lag sa audio but I can hear you now. I'll get straight to it, Niner. Nung pinapanood ko or nung nagre-read back ako sa nangyari sa oral hearing, parang it's one side here, one side there. So the countries like the US argued na dapat yung UNFCCC and Paris Agreement lang daw yung gamitin, while mga bansa tulad natin sinabi na we should use the whole gamut of international law, including international human rights law. Bakit ganito yung argument? Can clarify and maybe simplify that for us?
Sure. So for big emitters kasi like sila US, no, parang ang gusto nilang gamitin natin is yung UNFCCC and Paris Agreement kasi sinasabi nila, yun na yung climate change treaties talaga. So bakit hindi na lang yun yung gamitin nating basehan para sa lahat ng pag-uusapan natin? Ang challenge sa climate change agreements na gagamitin lang is voluntary and nationally determined contribution siya rather than actual ambitious legally binding obligations. So like sa Paris Agreement, bound sila to a process of submitting nationally determined contributions rather than actually submitting targets, no? So ang kulang dun sa UNFCCC and sa Paris Agreement is yung strong enforcement mechanisms or yung liability provisions, no? So merong principles of the convention na pinag-uusapan sa negotiations, pero yung interpretation kasi nila through implementation or through discussion and negotiations, medyo nagiging vague and politically negotiated na siya. Kaya yung mga developing countries, yung mga countries that are most vulnerable to the adverse effects of climate change, gusto nila yung ICJ i-consider yung broader set of laws, including customary international law, na na-mention niya na earlier, at saka human rights law, at saka other environmental treaties and principles. So pag sinabing customary international law, isa siya sa main sources of international law, alongside treaties and general principles of law, and it comes from the belief of states, it comes from state practice and their belief that they are legally obligated to act in a particular way. So kasama dito yung no harm rule, na baka marinig nyo mamaya, no? So because of that, if we include all of those other laws and sources of law, gaps in the UNFCCC and the Paris Agreement can be addressed. So they also establish kasi legally binding obligations which can expand state responsibilities that can cover yung actual conditions or context on the ground, no? Kasi climate change is cross-sectoral. Alam naman natin na hindi siya yun lang, di ba? It has human rights impacts, it has food security impacts, no? So kailangan makover natin yung lahat ng impacts niya to see how far climate change really goes in affecting the well-being of society, of humanity, no? So kailangan yung ambitious and legally binding obligations ma-determine through the examination of all of this gamut of legal instruments.
I have actually more questions, Niner, pero live na yung ICJ ngayon and
Okay,
nagsasalita na sila. So we'll go there. I'm sorry to cut you, but I'll just catch up with you later. Thank you, Niner Giao.
Thank you, Niner.
So we will go to the live stream of the United Nations. The ICJ has just begun its session. So let's watch.
Ano na bang what's happening? They're just settling in, no?
Habang wala
International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the United Nations Framework Convention on Climate Change, the Paris Agreement, the United Nations Convention on the Law of the Sea, the duty of due diligence, the rights recognized in the Universal Declaration of Human Rights, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment. A. What are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? B. What are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to 1. States, including in particular small island developing states, which, due to their geographical circumstances and the level of development, are injured or specifically affected by or particularly vulnerable to the adverse effects of climate change. 2. Peoples and individuals of the present and future generations affected by the adverse effects of climate change. End of quote. In accordance with the usual practice, I shall not read out the introductory paragraphs of the opinion. These paragraphs set out the main elements of the procedural history of the proceedings. I shall also omit or summarize some of the other paragraphs of the opinion. I shall therefore begin the reading of the advisory opinion at paragraph 37. The full text of the opinion will, of course, be available at the close of the sitting. When seized of a request for an advisory opinion, the court must first consider whether it has jurisdiction to give the opinion requested, and if so, whether there is any reason why the court should, in the exercise of its discretion, decline to answer the request. The first question put to the court concerns the obligation of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases, which I shall refer to as GHGs, for states and for present and future generations. The second question concerns the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment, with respect to states and peoples and individuals of the present and future generations affected by the adverse effects of the climate change. The Court considers that these questions are legal questions. The Court concludes that it has jurisdiction to render the requested opinion. It then concludes that there is no compelling reason for it to decline to give the opinion requested by the General Assembly. Turning to the relevant scientific background, the Court notes that the consequences of climate change are severe and far-reaching. They affect both natural ecosystems and human populations. These consequences underscore the urgent and existential threat posed by climate change. In its examination of the scientific aspect, the Court relies primarily on the reports of the Intergovernmental Panel on Climate Change, which I shall refer to as the IPCC. Participants agree that these reports constitute the best available science on the causes, nature, and consequences of climate change. The Court further observes that the adverse effects of climate change on the climate system have been acknowledged by the United Nations, including UNEP, and its specialized agencies such as the WMO, WHO, and the IMO. The IPCC defined the climate system as the global system consisting of 5 major components: the atmosphere, the hydrosphere, the cryosphere, the lithosphere, and the biosphere, and the interactions between them. For the purposes of this advisory opinion, the Court notes that this definition is substantially equivalent to that of Article 1, Paragraph 3 of the United Nations Framework Convention on Climate Change, which I shall refer to as the Framework Convention. Article 1, Paragraph 3 of the Convention defines the climate system as the totality of the atmosphere, hydrosphere, biosphere, and geosphere, and their interactions. The IPCC has concluded with very high confidence that risks, projected adverse impacts, and related loss and damage from climate change will escalate with every increment of global warming. It added that these risks, projected adverse impacts, and related loss and damage are higher for global warming of 1.5 degrees Celsius than at present, and even higher at 2 degrees Celsius. Indeed, in 2018, the IPCC concluded with high confidence that, I quote, warming of 1.5 degrees Celsius is not considered safe for most nations, communities, ecosystems, and sectors, and poses significant risks to natural and human systems, end of quote. The Court then turns to the scope of the questions posed by the General Assembly. Regarding their material scope, the Court considers that the 2 questions put to it are interrelated and require the Court to identify the obligation of states in respect of activities that adversely affect the climate system as well as the legal consequences arising from the breach of these obligations. In this regard, the Court is further of the view that the relevant conduct for the purposes of these advisory proceedings is not limited to conduct that in itself directly result in GHG emissions, but rather comprises all actions or omissions of states which result in the climate system and other parts of the environment being adversely affected by anthropogenic GHG emissions. The Court considers that the material scope of its inquiry encompasses the full range of human activities that contribute to climate change as a result of the emission of GHGs, including both consumption and production activities. Turning to the territorial scope of the request, it follows from the Court's conclusions on the material scope of the questions put to it that the General Assembly did not intend to impose any territorial limits to the Court's inquiry. The Court is requested to formulate its reply not in respect of any particular territory or regions, but in global terms, especially since GHG emissions are unequivocally caused by human activities which are not territorially limited. With regard to the temporal scope of the request, the Court observes that while temporal issues may be particularly relevant for an in concreto assessment of the responsibility of states for breaches of obligations pertaining to the protection of the climate system, the present opinion is not concerned with the invocation and determination of the responsibility of individual states or group of states. Rather, the present opinion considers the legal obligation of all states under question A and identifies the relevant legal regime applicable to legal consequences arising under those legal obligations in its reply to question B. Concerning the scope of question A, the Court notes that the unqualified reference to obligations under international law indicates the intention of the General Assembly to seek the Court's opinion on the obligations incumbent upon states under the entire corpus of international law, and not to limit the Court's reply to any particular source or area of international law. With regard to the scope of question B, the Court observes that this question is connected with question A insofar as it refers to the obligations enumerated in question A. Thus, the legal consequences to be determined by the Court are those arising from the various obligations under international law which the Court is called upon to identify under question A. In the Court's view, nothing in question B indicates that the General Assembly intended to request the Court to opine on the legal consequences, if any, for injuries arising out of acts not prohibited by international law. The Court considers that it has been requested to address legal consequences in a general manner, and that it is not called upon to identify the legal responsibility of any particular state or group of states. It also bears noting in this context that the responsibility of individual states or group of states requires an in concreto assessment that must be undertaken on a case-by-case basis. In its view, in relation to question B, the Court is only called upon, first, to establish the applicable legal framework of responsibility in respect of states that have breached their obligations to protect the climate system, and second, to outline in general terms the legal consequences flowing therefrom. In doing so, the Court does not prejudge the merits of any future claims that may be brought in relation to the subject matter of the present proceedings before courts or tribunals. As for legal consequences, with respect to a certain category of states that are especially affected or are particularly vulnerable, the Court notes that the application of rules of state responsibility under customary international law does not differ depending on the category or status of an injured state. Thus, specifically affected states or states that are particularly vulnerable are in principle entitled to the same remedies as other injured states. The challenges faced by certain states, owing to their geographical circumstances and level of development, are governed by the relevant primary rules of international law, and thus will be addressed by the Court in relation to the relevant obligations of states under Question A. The Court observes that the second part of Question B inquires about the legal consequences with respect to peoples and individuals of the present and future generations affected by the adverse effects of climate change. The Court considers that whether individuals have any entitlement to invoke the legal responsibility of states or to make a claim in a particular circumstance involving injury or harm arising from climate change is dependent on the relevant primary obligations of states. Having defined the scope and meaning of the questions posed by the General Assembly, the Court then addresses Question A and begins by considering the applicable law. In its request, General Assembly invites the Court to have particular regard to, I quote, the Charter of the United Nations, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the United Nations Framework Convention on Climate Change, the Paris Agreement, United Nations Convention on the Law of the Sea, the duty of due diligence, the rights recognized in the Universal Declaration of Human Rights, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment. End of quote. The phrase, particular regard to, while indicating that the wide range of international legal rules and principles are potentially relevant, does not mean that the General Assembly requests the Court to address every rule of international law, including the obligations contained therein in respect of climate change. The Court therefore identifies the most directly relevant applicable law governing the questions of which it has been seized. It first identifies those rules which are most directly relevant and thereafter determines whether any of those rules are excluded by virtue of the interpretative principle of lex specialis. The Court begins with the Charter of the United Nations, which is a pillar of contemporary international law. The Charter provides that the Member States shall act in accordance with certain principles, such as the fulfillment in good faith of the obligations assumed by states under the Charter, including when addressing problems of common concern, such as climate change. Accordingly, Charter forms part of the most directly relevant applicable law. The Court then turns to the applicability of the climate change treaties. It observes that the Framework Convention, the Kyoto Protocol, and the Paris Agreement are the principal legal instruments regulating the international response to the global problem of climate change. These instruments complement each other. Framework Convention establishes the ultimate objective as well as the basic principles and general obligation of states in respect of climate change, whereas the Kyoto Protocol and Paris Agreement respectively translate these basic principles and general obligations into a set of more specific interrelated obligations, each of which gives expression to a broad, practical approach of the community of states parties to the problem of climate change. The Court thus concludes that the three climate change treaties, namely the Framework Convention, the Kyoto Protocol, and the Paris Agreement, form part of the most directly relevant applicable law. In view of the Court, UNCLOS also forms part of the most directly relevant applicable law. With respect to other environmental treaties, the Court considers that the following treaties form part of the most directly relevant applicable law, given their close connection with the issue of climate change. The Vienna Convention for the Protection of the Ozone Layer, which I shall refer to as the Ozone Layer Convention, the Montreal Protocol on Substances that Deplete the Ozone Layer, which I shall refer to as the Montreal Protocol, the Convention on Biological Diversity, which I shall refer to as the Biodiversity Convention, and the United Nations Convention to combat desertification in those countries experiencing serious drought and/or desertification, particularly in Africa, which I shall refer to as the Desertification Convention. The Court is aware that there are many other treaties which are relevant for the efforts of the international community of states to address the global problem of climate change. However, it confines itself to examining the most directly relevant applicable law regarding climate change. The Court then goes on to consider the applicability of the relevance of customary international law. In the advisory opinion on the legality of the threat or use of nuclear weapons, the Court affirmed that the duty to prevent significant harm to the environment is not confined to instances of direct cross-border harm, and that it applies to global environmental concerns. In the Court's view, the customary duty to prevent significant harm to the environment also applies with respect to the climate system and other parts of the environment. The duty to prevent significant harm to the environment is an obligation to act with due diligence. The conduct required by due diligence has several elements to which I shall return later. Determination of what is required by due diligence ultimately calls for an assessment in concreto of what is reasonable and under the specific circumstances in which a state finds itself. However, this does not exclude the identification of a required standard of conduct at the general level depending on the overall character of the risk to the parts of the environment in question. This is particularly apposite with respect to climate change because the specific character of the risk of significant harm to the climate system is indisputably established. Climate change poses a quintessentially universal risk to all states. This risk is of a general and urgent character, requiring the identification of a corresponding general standard of conduct to be applied subject to the principle of common but differentiated responsibility and respective capabilities. Under these circumstances, the Court recognizes that the standard of due diligence for preventing significant harm to the climate system is stringent. As concerns climate change, a heightened degree of vigilance and prevention is required. The Court concludes that the duty of states to prevent significant environmental harm applies in the context of climate change, and that this duty forms part of the most directly relevant applicable law. Concerning the duty to cooperate, the Court recalls that it lies at the core of the Charter of the United Nations and has been spelled out in the Foundational Declaration on Friendly Relations. Court has held that the adoption by states of this text affords an indication of their opinio juris as to customary international law. That observation also applies to the duty to cooperate, insofar as it finds expression in many binding and non-binding instruments relating specifically to the environment. The duty to cooperate is a central obligation under the climate change treaties and other environmental treaties. In view of the related practice of states, the Court considers that the duty of states to cooperate for the protection of the environment is a rule whose customary character has been established. This duty to cooperate is intrinsically linked to the duty to prevent significant harm to the environment, because uncoordinated individual efforts by states may not lead to a meaningful result. It also derives from the principle that the conservation and management of shared resources and the environment are based on shared interests and governed by the principle of good faith. For these reasons, the Court considers that the duty to cooperate for the protection of the environment forms part of the customary international law and can also serve as a guiding principle for the interpretation of other rules. It forms part of the most directly relevant applicable law. Turning to human rights law, the Court considers that the core human rights treaties and the human rights recognized under customary international law form part of the most directly relevant applicable law. The Court then examines whether certain principles are part of the applicable law for the purposes of the present advisory opinion. It concludes that the principles of sustainable development, common but differentiated responsibilities and respective capabilities, equity, intergenerational equity, and the precautionary approach or principle are applicable as guiding principles for the interpretation and application of the most strictly relevant legal rules. The Court finally turns to the question of whether any of the rules identified above are excluded by virtue of the interpretative principle of lex specialis. This question concerns the relationship between the climate change treaties and other rules of international law. The Court notes at the outset that it is a generally recognized principle that when several rules bear on the single issue, they should, to the extent possible, be interpreted so as to give rise to a single set of compatible obligations. The principle of lex specialis is a maxim of interpretation that is used for determining which of several potentially applicable rules is to prevail, or whether the rules simply coexist. The application of the lex specialis principle depends on the circumstances of each case. The Court cannot find any actual inconsistency between the provisions of the climate treaties and other rules and principles of international law that may be relevant for the response to question A. On the contrary, the preambles to the Framework Convention and the Paris Agreement themselves contain references to other rules and principles. The state parties to these treaties have thereby recognized that climate change constitutes a problem for whose solution other rules and principles also play a role. Nor can the Court identify a discernible intention of the parties to the climate change treaties generally to displace other possibly applicable rules or principles. There is in particular no indication that the climate change treaties are meant to apply while simultaneously excluding general custom international law or other treaty rules on the protection of the environment. For these reasons, the Court considers that the argument according to which the climate change treaties constitute the only relevant applicable law cannot be upheld, and finds that the principle of lex specialis does not lead to a general exclusion by the climate change treaties of other rules of international law. The Court emphasizes that it has determined only the applicable law which is most directly relevant for answering question A put to it by the General Assembly. This determination is without prejudice to other rules of international law that may also be relevant under various circumstances in the context of climate change. The Court then turns to the obligation of states under the Climate Change Treaty Framework, which comprises 3 legal binding instruments concluded by states to address the problem of climate change caused by anthropogenic GHG emissions, namely the Framework Convention, the Kyoto Protocol, and the Paris Agreement. The Court takes into consideration the rules, principles, mechanisms, and institutions established under the climate change treaties in order to identify and clarify the obligation of the parties. In this context, the key principles that permeate all 3 climate change treaties are those contained in Article 3 of the Framework Convention. These guiding principles include common but differentiated responsibilities and respective capabilities, the precautionary approach of principle, sustainable development, equity, and intergenerational equity. The Court recalls that while these principles do not constitute standalone obligations within the Climate Change Treaty framework, they guide the interpretation of the treaty obligations. In interpreting their obligations under the climate change treaties, states also need to have recourse to the relevant decisions of the governing bodies of these treaties, which are the Conference of the Parties of the Framework Convention, the Conference of the Parties serving as the meeting of the parties to the Kyoto Protocol, and the Conference of the Parties serving as the meeting of the parties to the Paris Agreement. The Court observes that in certain circumstances, the decision of these bodies have certain legal effects. First, when the treaty so provides, the decision of Conference of Parties may create legally binding obligations for the parties. Second, decisions of these bodies may constitute subsequent agreements under Article 31, Paragraph 3A of the Vienna Convention on the Law of Treaties, insofar as such decisions express agreement in substance between the parties regarding the interpretation of the relevant treaty. The Court observes that it is not required to address each and every obligation of the parties under the climate change treaties. It focuses its inquiry on the main obligations of states under the Framework Convention, the Kyoto Protocol, and the Paris Agreement pertaining to the obligation to protect the climate system from anthropogenic GHG emissions, which it considers may be grouped broadly into obligations of mitigation, adaptation, and cooperation. Concerning the relationship between the Framework Convention, the Kyoto Protocol, and the Paris Agreement, the Court observes, with respect to the applicability of lex posterior rule, that it is only where the treaties are incompatible, i.e., the obligations cannot be complied with simultaneously, that the later in time obligations will supersede the earlier obligation. The mere fact that the treaties regulate the same subject matter does not necessarily constitute a conflict or result in one superseding the other. In the view of the Court, there is no incompatibility between the three climate change treaties. On the contrary, they are mutually supportive, with the Kyoto Protocol and Paris Agreement providing greater specification to the general obligations contained in the Framework Convention. The Court turns to the obligation of parties under the Framework Convention. It observes